A big hello and a warm welcome to everyone out there to Immigration and Jobs Talk Show. I am Nipasa Pradhan and thank you for joining us today, wherever you're joining us from. And we are streaming live right now in YouTube, LinkedIn, Facebook, and Twitter. And thank you so much, friends out there, for joining us today. It's going to be a very, very exciting session today as well, because we are going to be joined by none other than attorney Chand Parvathaneni, who has joined us previously for many webinars. Once again, welcome back to Immigration and Jobs Talk Show, Chand. How are you doing today?
Thank you, Nipasa. Pretty good, and hope everybody who has joined in is doing great. And hopefully, we'll have a very informative discussion today again.
Absolutely, we will. And before we start off, I wanted to uh, give out this very important disclaimer, which you can already see on the screen. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So, use of information is at your own risk. And friends out there, I'm Nipasa Pradhan. I'm going to be with you for the next hour. And we're going to have a very, very insightful session with immigration attorney Chand Parvathaneni from SPB Law Firm, Dallas, Texas. And he has been practicing law for so long now. And thank you so much, Chand, once again. This is going to be our second episode, a continuation of our previous discussion with Chand we had. The topic today is H1B RFE trends and consular process versus change of status for H1B. So we already had a short discussion last time as well, an hour. So we took up many questions from you. Thank you so much today as well. I hope it's going to be very participative. And don't forget to tell us, about where you're joining us from. I mean, the city, the state, where are you joining us from, so that we can have better answers and more precise answers for you, right, Chand?
Yeah, that is correct. So today, hopefully, we will discuss on the recent RFE trends that are happening on the H1B side. And for everybody, what's happening right now is the cap filings. The very first time people who get onto H1B, the cap, the ones that just got selected in the lottery, those H1B filings are happening right now. And a lot of times, what happens is people are in US and they're typically on an F1 visa or some other visa like H4 or L1. The normal way to do things are you file the H1B with a change of status request. So you want somebody's status
Mhm.
to convert from F1 OPT or CPT or STEM OPT or H4 to H1. So you always file it with change of status typically. However, recently we're seeing a trend where more and more people, especially the people who have STEM OPT for a couple more years, we are seeing a trend where people really want their H1Bs to be filed as a consular processing case and not really as a change of status case. So I think we will use this session to discuss why exactly people want to pursue the consular processing route, why some people want to do the change of status route. In both cases, the H1B will get approved, but what is the difference and what are the advantages over one versus another one? So we will talk about that. And also, in general, the RFE trends. We started off discussing about the recent H1B RFEs last time. We will continue the discussion. And as viewers have more questions, we will talk about specific RFEs. But overall, we have started the filings. And what we're seeing is we are seeing the same process as last year. Nothing majorly has changed in terms of approvals, in terms of the questions being asked, in terms of the burden of proof to prove your case, to prove your H1B case. It's all same as last year. And what that means is the approval is in like high 90s. So USCIS in general, majority of the cases get approved. And H1Bs are filed by companies who are serious because the companies have a liability to pay a lot of very high salaries. So in general, majority of the cases do get approved. And based on the statistics, we can tell that the approval rate is in high 90s. So in general, things pretty much like last year, nothing, no major regulation changes, and things are going smooth. And we'll discuss more as our session goes along today.
For sure. Absolutely, friends out there. Stay with us. And I'll just say hi to Super Channel and Neha Seti for joining us. Keep dropping your questions. And yes, if you have questions, especially under the topic H1B, RFE trends, consular process, change of status, tell us about where you are joining us from and what is your status as well, so that we can give out perfect answers. Anyway, Chand, let's dive in to today's topic and the questions I got for you. So, first off, let's if you could tell us how might transferring universities, before completing the first semester, impact somebody's H1B visa application? Will it raise chances of an RFE? And if so, how should the person respond? And is it advisable given their financial concerns as well?
Sure. So we always see some people who come on F1 visa, and sometimes they change their university, maybe the very first semester, maybe the second semester, and we see this happen. They have a visa with one university, but once they come to US, they keep changing their universities. And when we file the H1, and if somebody is on F1 visa, and if somebody is on F1 in United States, and they're trying to change their status to H1, very commonly USCIS issues an RFE and wants us to prove that the F1 beneficiary, he or she maintained their status, their valid F1 status throughout their stay in US. So it's a very common question that we get once in a while. And what that means is university changes are allowed, but if there is some issue during transfer, if the service is not updated properly, the risk of an RFE will increase. That being said,
Mhm.
as long as somebody is able to prove that they have done the transfer properly, the service got transferred, they've completed all their coursework, they have attended classes full time in person, and there are a couple of things to prove. If they're able to prove it, even if there's an RFE, they should be able to prevail. But the bottom line is, whatever is done, it has to be done in a proper fashion. Go through the school DSO, make sure the school DSO is in line with them. And at each point of time, the school DSO is confirming that the service is valid and their F1 status is valid. Uh, by paying close attention to the rules, ensuring their service is transferred to the new school, the RFE should be minimized. And even if there is an RFE, most of the time, if that person has attended classes, he has passed all the classes, in general, it is not a tough RFE.
Okay. Okay. Thank you so much for taking that up, Chand. And I think let's just go quickly to the next one, which is also about, mm, you know, H1B consular interview. If one proceeds with their H1B consular interview, if others from employer face 221G this year, is the same person likely to encounter, the same thing? And also, the employer suggests waiting for 2 months. So, is it advisable? What would you say?
Sure. So a 221G means their visa is refused, and it does not mean the visa is denied. It just means it is temporarily refused, and the consular office, the consulate, the Department of State, they typically what they do is they initiate background checks and they start their process. It could take some time. Sometimes it is quick. Sometimes it could take some time. And during the 221G, they are doing a lot of background checks, probably on the company, probably on the employee, maybe on the end client. It could be anything, and sometimes it could be a very simple thing, maybe on the employee's education. But there is something going on. There is some kind of a background that needs to be cleared before the visa gets approved. So when somebody in a company gets a 221G, I've seen a lot of times the companies get worried and they recommend their other employees who are about to go for stamping to take a step back until this other 221G is cleared. So again, in my opinion, what should be done is if the company is decently large enough, they have a lot of employees who got their visas in the past. Uh, there is no reason to wait. The next person can just go. But again, if the company is relatively a new company, I typically would give some time, like a month or two, because what Department of State is doing is once the 221G is issued, they're doing some background checks. So maybe giving them a month or two for a brand new company, it will help the background checks to be over and the records to be updated, their PIMS database to be updated. And if they don't do that, if the next person goes immediately, so maybe they are still waiting on some background check about that petitioner, and they're just going to give a 221G event to the next guy. So again, it is a decision that they have to kind of make. The company has to make based on their specific case. In some cases, it might be better to wait for some time before their next employee goes for stamping, And in some cases, if the company is a large company, I would not worry. They can just go even if there is one case under 221G.
Okay, thank you. Thank you. And friends, 221G is also a huge topic, actually. So we will take this up and maybe have a whole discussion, one whole episode for it, Chand. All right, very soon, I hope. And all right, so I think I will just take up a few from the audience since they're here and dropping in so many questions. So, Super Channel is saying, I'm from Andhra Pradesh. Nice to meet you all. May I know the recent changes in H1B approval? Yes, maybe you could also tell us about some updates from the visa bulletin that recently came out, if you have anything to share with us, Chand.
Sure. So, in terms of the recent changes for H1B approval, nothing really has changed in the last 1-2 years. The rules are still the same. The only major changes that have come in H1B this year is that starting from April 1st, we are able to e-file instead of the paper filing that we normally do. Now we have an additional means of filing the petition. And we have started e-filing. We are seeing a lot of challenges in e-filing. The filing is not smooth. The system is extremely slow. So we are kind of doing both right now. We're doing e-filing and paper filing. So in terms of the major changes, e-filing is like one of the major changes that has happened on the H1B side. And this just started April 1st. So from April 1st, especially for all the cap cases, we are able to e-file. And in terms of approvals, there is another major change for the premium processing. So for the premium processing, starting from April 1st, it is now 15 business days rather than 15 days it used to be. So the premium processing cases could get delayed a little bit, not a whole lot, but now it is 15 business days. So that is another change. And another change in the H1Bs is more to do with the fee. The fee has increased drastically starting from April 1st. So for every company who's filing the H1B, the filing fee has increased. And for some companies, the fee is drastically higher than what it used to be. But the bottom line is every company, a small company, a large company, all of them are impacted. The fee increase for the small companies, which hire less than 25, is a little bit less. And for companies who currently employ 25 or more employees, the fee increase is a little high right now. So in terms of the changes, these are the main changes that we have seen recently. And in terms of the trends, the approval rate, we are kind of seeing a consistent approval rate like last year. It is in high 90s, and we expect that to still continue. Yes, there is a talk about a lot of layoffs in the IT industry. That being said, we are still seeing a lot of demand. And the reason we are saying that is because we have a lot of filings that are being filed in our law firm for new employments, for amendments, for transfers. So what that means is in the IT profession, in spite of the recession talk, in spite of the layoffs, there are still employers who are still hiring. So the big companies, the big players are probably laying off people, but the small players, the startups, the mid-sized companies, the small companies, they are actually grabbing up all these employees because all these employees were not available to them previously. But now, because the big companies are laying off people, the small companies now have a wider pool of good employees. So it looks like what's happening right now is a lot of small companies are hiring, and the hiring is continuing. I mean, things are not. I mean, in terms of the recruitment, it's not that there are complete layoffs in every industry or every segment. There are still a lot of companies that are hiring, and because of that reason, we still expect the approval rate to be high on the USCIS side. And then once the approval happens here, the consulate. On the consulate side, we did see some challenges in December and January. Things were a little bit slow. And again, recently, if you look at what's happening in March and April, looks like the stampings have the success rate has actually gone up. And the stampings, this is what will happen. Even if somebody gets a 221G, majority of the 221Gs will get cleared for H1Bs because the consulate will do the background checks, they will initiate all these things, and most of the cases will get approved down the line. So what that means is, even on the India side, the H1Bs, even if a few folks, even if a lot of folks get 221Gs, there is nothing to panic. The company will get, I mean, down the line, the company will be able to clear out the 221Gs. So overall, we are not really seeing like a lot of denials either on the USCIS side or
Mm.
even on the consulate side.
Okay. Thank you so much for taking that up. And I hope that, well, you got your answer. Next up, let's take up, it's already showing on the screen. This is from Hari in YouTube's asking, Hi Chancellor, we got our green card EAD for 5 years. AP pending. Wife and elder kid started using EAD. Primary on H1, younger kid on H4. How about to start the H1 extension process? How to apply the H4 for spouse who is on EAD?
Sure. So when you say green card, so I'm assuming that you have a pending 485. So you have a pending 485, and then looks like the primary spouse, you are on H1. And what that means is, if you are maintaining H1 status, your spouse, she has two choices. One, she's allowed to file for a H4 extension, so she can be on H4 because the primary is on H1, or she has a choice. The H4 is just a choice. She is good to stay on 485, basically pending 485. So pending 485 lets you stay in the country as long as 485 is pending. That being said, I always recommend H4. Even though you're having an EAD card, it's always good to have H4 because that's a good backup. So if something were to ever happen to a 485, you have a backup, which is why if the primary is maintaining H1, the spouse, it's always a good idea to be on H4, the spouse or the child to be on H4. And the reason for that is, I recently had a case, I had a consultation where this person came to me and said he got an RFE for medicals and they didn't see it and they missed it. So the 485 got denied, and they were not maintaining H1 and H4 status. So all of a sudden they were out of status. So to avoid those kind of uncertain situations, if you are in a state where you can maintain H1 for yourself and H4 for your dependents, it's good to maintain. And again, it's a choice. Your dependents don't have to have an H4. Even if they don't have an H4, they are good as long as the 485 is pending. But if they have a choice and you're willing to spend that money to get that H4, it is not expensive. The H4 application, it's $470. So the way I see it is, it's always good to have a backup. So always file for the H4 extension, either for your spouse or for your child, or for both spouse and child together. Again, it's up to you how you want to do it, whether you want to do it for your spouse and children, or maybe only for one child. It's up to you. But as much as possible, it's always a great idea to have a second backup, which is a H4 on top of your 485.
Mhm. Okay, thank you so much for that suggestion. And Hari, I hope that that was pretty much what you needed. And if you have any more questions, we are here for some time. So keep dropping your questions in the comments. We'll be happy to take them. And also, friends, it would be really nice to get to know where you are joining us from. So don't forget to tell us which city or state you have joined us also. And moving ahead, let's take up Chaitanya, which is already showing on screen on YouTube. He's asking, what are the implications for travel plans and work authorization while waiting for an H1B visa under consular processing versus change of status?
Sure. So normally, what people hear is, if your H1B is getting filed and you are in US, you should not travel out of the country. That's the general rule that you typically hear. And however, that rule pertains to those folks who are pursuing H1B with a change of status. So if your employer is filing a H1B with change of status, you should not typically travel out of the country. If you travel out of the country, the change of status will be denied. And if your employer is filing under consular processing, even if you travel, there is no impact. So what that means is, if your employer has filed a H1B with consular processing, then you are good to travel even while the H1B petition is pending. So even while it is still pending, you're good to go to India, travel, come back. Your H1B will not be impacted. So in terms of travel, it's always good to, if you have plans for travel, it's always good to file it under consular processing, not change of status. If you don't have plans for travel, change of status could be a good idea. Again, there are reasons why sometimes, even though you don't have travel plans, you want to do it in consular processing. But it's a different question. at least specific to your question, if you want to travel, definitely do it in consular, because change of status will get denied if you travel, if it is filed as a change of status filing.
Much. Thank you so much, Chand, for taking that up as well. Chaitanya, thank you so much for your question. And if you could also tell us where you have joined us from, it would be great to know. All right, Chand, moving ahead, there are more questions which we will take up from Minu and even Basma. Stay with us. All right, we'll just take them after a few questions from our side. So, Chand, if an F1 OPT holder selected in the H1B lottery faces 221G in India for stamping, can they return to the US and work on OPT while waiting the 221G result, even if their OPT expires within 2 years?
Sure. So I think if somebody is on F1 OPT and they also have an H1B approval, the first thing I think you're supposed to look for is look on the approval and see if it says change of status has been approved. If your change of status has been approved on the H1B petition, it will say change of status is approved. The reason is if your change of status is approved, starting from that date, your F1 OPT is not valid anymore. So your F1 OPT, your service will get terminated. So if you have been granted change of status, and from that date your service has been terminated, you pretty much cannot use F1 OPT. However, there is this other scenario. Say your H1B was filed under consular processing, and your approval says it is consular processing. It does not say change of status, and then you go for stamping. Say your H1B stamping is under 221G. If that is the case, just make sure you contact your school, make sure your service is active, make sure if your service is active, you are allowed to use your, if you have a valid F1 visa, you're allowed to use the F1 visa. You're allowed to come back and continue under F1 status. Okay, so if your service is active and you have not received a change of status, you are good to come back on F1 OPT and continue being in F1 OPT and ensure that you comply with all the regulations of OPT program. If you do that, yes, even if there is a pending 221G for H1B, you could potentially come back and continue on F1 status.
Cool. Thank you so much for taking that up, Chand. And friends out there, also, there's, like I said earlier, we will take up this topic. It's very vast, and there would be so many questions you folks also have about 221G. So we will definitely keep this in mind. Chand, we'll cover this, all right? And also, Chand, when completing DS 160 for H1B after F1 rejection, what should one write in the section explaining my previous visa refusal? And it was due to 214B, despite over 10 years, and their F1 status still shows as refused.
Sure. So whenever anybody's filling up the DS 160, there is this question that talks about, have you ever had any prior visa refusals or revocations? And if any, and it is highly important that the accurate statements be put in DS 160. And what that means is, even if it is 10 years back, even before 10 years somebody got a visa refusal, they are still required to disclose that, say that yes, their visa was refused, at least write a simple line on that topic. Maybe as simple as in year 2010, for example, I attended the F1 visa stamping. It was refused based on this clause. Uh, Even like a simple liner. It is something what one should mention, because once they give basic information, the consulate might be able to check what exactly happened. But at least it is the applicant's responsibility that they do answer that question and at least put a small snippet of what happened. And in this case, it was 214B. So 214B typically for a F1, what it means is they feel that somebody could go to US and study, but they probably will not come back to India because they don't really have strong ties to India. That's probably what the officer felt. So if the officer feels that this person might not come back or might not have strong ties to his home country, it could be a refusal. With F1 visa, it's a problem. With H1 visa, however, that is not a problem, because H1B is a dual intent visa. So somebody can go to US with the intent of immigrating to US down the line using legal avenues. So a 221G for F1 refusal will not impact the H1B visa application, but the applicant, it is their responsibility to ensure that that information is actually put in the DS 160. But overall, I don't think it'll impact their visa application at all.
Okay, thank you for that, taking that up, Chand. And also, we have Harsha Jain. Thank you so much for your questions. Meenu as well. We will take them up. Just stay with us, all right? For now, though, Chand, I also wanted to ask you, um, what if someone got their H1B approved recently while in the US? Can the person qualify for interview waiver if he or she or they travel to India for stamping? Also, are consulate appointments scarce?
Yeah. So the good thing is, if anybody has a US visa in the past, more than likely they will qualify for interview waiver. And the way they would know it is when they're answering, when they're filling up their DS 160. There are a few
Mhm.
questions. It'll ask a few questions. Did you have a US visa in the past? Basic questions. And when you answer that question, it will tell you if you are eligible for the drop box. And in this case, if this employee has been in the United States and this case got approved, that means that they have a visa of some kind because they're already in US.
Mhm.
And what that means
Right.
is more than likely they will qualify for Dropbox. And when they fill up their DS 160, schedule their visa appointment, they should be able to get that option, the waiver option. And my suggestion is whoever gets the waiver option, they should take it because waiver typically is a lot easier than interview. However, even if they select the waiver option, the consulate, in some cases, what they could do is they could always call somebody back for the interview. So that's always a possibility. But at least initially, upfront, the person should get the Dropbox, the interview waiver. And to me, that is like the most easiest and the cleanest way to go about. And that being said, the appointments are scarce. But again, what I see is people keep on repeatedly checking the website, and the slots keep opening up. So if you don't see slots for the period that you want to book an appointment, just keep rechecking. And as you keep rechecking, as slots get opened up, you will find visa appointments.
Great. Okay. Thank you so much for taking that up as well, Chand. And, friends, I think we will surely go for a break now. But before the break, I wanted to tell you that if you want to directly contact Attorney Chand Parvathaneni, the details are on the screen, friends. You can call him in the number 817-523-8247. You can even email him at law@spblawfirm.com and also visit his website that is spblawfirm.com. So this is Chand Parvathaneni from Dallas, Texas. And on Immigration and Jobs Talk Show, friends, today we are speaking about H1B RFE trends, consular processing, and H1B status. Thank you so much. Stay with us. We will definitely dive deeper into this topic. Um, let's go for a short break.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com.
Hello, everyone, and welcome back to Immigration and Jobs Talk Show. This is Nipasa Pradhan, and this is the second half. Welcome back after the break. Today, we are discussing about the H1B RFE trends and consular process versus change of status for H1B. And friends, we have none other than our very special guest, immigration attorney Chand Parvathaneni. Thank you so much, Chand, for doing this with us today. It's been great chatting with you so far.
Thank you, Nipasa.
Always very insightful. Thank you so much for explaining each and every question so well. And folks out there, we will take up your questions. Just stay with us, and wherever you're joining us from, and even if you're watching this after the streaming, you can drop your questions. Have any questions, just drop them in the comments. We will take them up for you. All right. And also, Chand, let's move on. I got some more questions for you, and I wanted to know if it is problematic, if client details are not listed in Form I-129 or LCA, despite being in LCA and form. And will this affect their visa interview?
So, so the client details are not always required because so on the I-129 you always have to put the work site where the employee is working at, and you don't really have to put the client name. And on the LCA, however, you have to put whoever is controlling that work site. So if somebody is working at the client location, we have to put the client name. But a lot of H1B cases, people are not really working at the client location. They're probably working at a remote location that is controlled uh, by the petitioner, or maybe sometimes from their home address, or maybe just from their the petitioner's office. If that is the case, the client name is not even required on the LCA. The client name is required only if that work location is operated by the end client. So we do have a lot of cases where the client name doesn't even show up on the I-129 or the LCA because somebody is not really working at the client location. And that is completely valid because people keep getting assigned to multiple projects. They're on one project at a certain time and another project at a certain time, and they're not really working at the client location. So depending on the situation, it is not a mandatory thing, and not having the client location doesn't mean it's an automatic denial or an automatic 221G. Every company's case is different. So it all depends on where exactly the employee is working, what exactly is the project, what exactly are his job duties, what is the salary he's getting paid. These are what would determine the overall strength of the case. If somebody is working in an occupation where the salary is not very high, or if somebody is working in a occupation with a very low salary, so all of those things could impact the final adjudication. The officers, the USCIS officers, or everybody involved, they want to make sure the program uh, is conforming to the spirit of the regulations. And what that means is nobody wants the H1B program to be an avenue to bring in cheap labor. Everybody wants H1B to be a program where you get talented people, not cheap labor. And that is what happens. So majority of the companies are using H1B to get very highly educated employees, highly talented employees who have very specific technology skills. These technology skills are not in US, which is why we are getting people on H1B. So the bottom line is the strength of the case is more on what exactly is the employee doing, what kind of job duties the employee is doing, rather than the other things. So the client details are definitely not mandatory, and we have numerous cases where it is not dependent on a single client, where the petition, it is not filed for a particular employee to work only for a particular client for the entire 3 years. So depending on on the situation, how the company is doing the filing, what exactly is their underlying assignment, you may or may not have the client information, and that's perfectly okay.
Okay, thank you so much, Chan, for that. And yes, so friends out there, not to worry if you do not have the client information yet, um, but the other things which are very important, you have to be able to provide them. So, all right, so Chan, let's move on to another question which I got for you, and that is, does one only need to submit tuition fee receipts or also show the source of income for RFE proof?
So lately, we have been seeing a lot of the I-765 RFEs, where they're specifically asking about the tuition fee receipts. They're also asking of source of income. They're also asking about bank statements. And clearly, it looks like a new trend because 765, it used to be rare to see an RFE for 765. But lately, we are seeing all these RFEs for the STEM OPT extensions or the OPT filings, which are the 765 filings, where they're repeatedly getting asked about these tuition fee receipts, the source of income, the bank statements, and so on. And again, So the goal of, again, when you answer these RFEs, the goal is to prove that you have maintained a valid F1 status. As long as you're able to prove that, typically you should be able to get the case approved. And what that means is, we typically, as a whole, we see what documents are getting asked, and you don't really have to provide each and every document that is listed in the RFE, but as a whole, the list of documents is a recommendation from the officer to provide those documents. But uh, the RFE will tell you what exactly is the topic they're asking about. Maybe it is a full course of study. Maybe it is about their employment history. Maybe it is about their something else. So if you can, I mean, again, it doesn't really, you don't really need to show everything they ask for. But again, something like tuition fee receipts are very important. The tuition fee receipts, the transcripts, most of the time they are very, very important. And the source of income, again, it depends on under what context they're asking about it. Sometimes you have to show the source of income. Sometimes you do not.
Mhm.
And the tuition fee receipts, if they are requested, we always recommend that they do provide that. And the source of income, sometimes if they're getting funded by some of their relatives to pay their tuition, we simply use an affidavit. Simply take an affidavit from their relative saying he is the one that has paid, show the tuition receipt as the corroborating evidence, and move along.
Okay. Thank you. Thank you for clearing that out for us, Chand. And also, let's take up this one more. What are the top three reasons for receiving an RFE on an H1 visa, or an L visa, or an F visa? And how can one effectively respond to each one of them?
Sure.
Common
I
ones,
think
quick ones.
Sure. The number one reason is like something is really missing in the file, something like very, very mandatory document. For example, if somebody's on H1, L1, or F1, they are supposed to maintain their status. And for example, for F1, they're supposed to have a valid I-20. For L1, they're supposed to have employment, which means they have to show their pay statements. Same thing for H1. If somebody's on H1, they have to maintain their H1 status. So the pay statements are mandatory. So if the mandatory documents are missing, that is always a guaranteed reason for the RFE. And the second reason that we typically say is, even if everything is good, maybe the officer, the case went to an officer who is just giving an RFE, because we have some cases where the same exact company, same exact set of documents go to one officer. He does not have a problem. Another officer has a problem. And what that means is,
Mm,
every officer has a different way of looking at things. So if one officer is not satisfied, so maybe it is just that officer who is like not clear on what exactly is that issue, and they're requesting some clarification. They're doing their job, so they're asking for some clarification. So basically, just that officer wanted to clarify something. Even sometimes it could be in the
mm,
file, but the officer probably needs some extra clarification. That's another thing.
mm,
And the third main reason that we see is, typically, I mean, documents are all provided, but there is some like ambiguity that the document has caused. For example, there is a client letter and there is a vendor letter, and they're in conflict. For example,
mhm,
so maybe one is talking about a project for 3 years, maybe one is talking about a project for 6 months, maybe one is talking about the qualifications as computer science information technology. The other document is saying the qualifications are maybe an MBA, for example. There's a conflict. There is an ambiguity with the documents that are provided. So sometimes uh, uh, putting in a whole bunch of documents also causes a problem. So in our law firm, the goal is, we only provide those documents that are required as per the regulatory burden. Just because you have some documents, if you keep on putting all those documents to increase the size of your file, sometimes we see RFEs. Uh, so what that means is, people have to be careful. If not required, if not requested, don't provide and complicate your filing. So keep the filing
mhm.
simple, because sometimes you're providing all the information, but you've provided so much of information that it is creating an ambiguity, and the officer is confused. So because they're confused, they're actually having to issue an RFE and get more clarifications.
True. True. And without fail, I think we have to, avail proof for each RFE friend. So not to worry. It's just a request for more proof. It's not a denial. We always say that. So you just go on, head on to whatever they've asked for and go give them proof of every bit supporting your document. All right. So, Chan, let's move on also to another question. And that is, um, when should one resign from their current job after receiving the offer letter and H1B lottery selection? And are there any risks of rejection during the submission process?
Sure. So I think I get this question a lot because they got an offer from some employer and it got selected in the lottery. The question that I get is, do you have to immediately quit your current job and join this new employer? Um, the answer is no. For H1B, somebody does not have to be an employee of that company. Somebody can be in India and they could have received a job offer, or you can be here working for another company and you receive this company's job offer. So the rule is, when the company is filing a H1B cap petition, the start date is October 1st or after October 1st. And what it means is, until October 1st or later, one does not even have to be an employee. So if you are having another job and you receive an offer letter and this other company is filing a H1B under cap, this company is filing for H1B starting from October 1st or later. So until October 1st, you don't really have to resign this other job and come to this company legally. So legally, you technically can still work for this other company as long as your intention is to join this company after October 1st or after the approval. So what that means is, again, if your offer with this company is something that is critical and you have to start right away, yes, go ahead and start it. But in terms of the regulatory burden, if you need to take time, you are allowed to take time. There is no requirement that says that for a company to file a H1B, you have to be on their payroll or you have to be their employee. You don't have to. That being said, in the practical world, what happens is, a company does not have the motivation to file a H1B if you're not really working for them. Because if you're working for them, to them, it makes sense that they're wanting to extend your work status. So that is why we see a lot of companies saying, hey, if you're employed by us, we will file the H1B. So it is more of a practical thing where people become their employees before the H1B gets filed. But from a regulations perspective, even if you're not that company's employee, that company is still able to file the H1B petition because the cap filings all start from October 1st or after that date.
Okay. Okay. Thank you so much. Thank you so much for taking that up as well, Chand. Let's move on to some questions from our viewers. And this is on YouTube from Basma. How does the choice between consular processing and change of status impact the overall timeline and success rate of H1B visa approval?
So again, so my experience is consular processing is always easy from my perspective. From as a lawyer working on a case, my burden becomes a lot lesser if I'm filing for a consular processing case. The reason is, if I'm filing for a change of status, I have to prove that somebody is in US and maintaining their status, they're in a valid status. So if somebody's on H1, sorry, if somebody's on F1 OPT, I have to make sure they have I-20s. I have to make sure they have their EAD card. I have to make sure their pay statements are there before I can request for change of status. If anything is wrong, if anything is a problem with the pay statements or anything of that sort, or we will not be able to file under change of status. With consular processing, what happens is, you don't really have to prove somebody is maintaining their status in the United States. And what that means is, if somebody is missing some pay statements, it should be okay because you're filing it under consular processing. So somebody is actually going to go for a visa stamping. You don't really have to prove that somebody is maintaining their status at the time of filing. So, so at least if you say from an approval perspective, H1B is the approval consists of two parts. One, the H1B, the position approval itself. The second one is the change of status approval. So if you don't require the change of status approval, you're saying you require consular processing approval, your little bit of your burden goes down because you're not really having to prove that entire maintenance of status part. So the timeline, as well as the complexity of a case, uh, I think decreases, and definitely consular processing is a little bit easier in terms of filing. That being said, everybody's case is different. Some people who are completing their OPT maybe in the next couple of months, they don't have a choice. They have to do a change of status. If they do it as counselor, they have to go out of the country and risk not finding a stamping date and all those things. So consular processing will not work for everybody. However, if people have OPT for a long time, say if somebody still has STEM OPT for 2 more years, those are potentially good candidates for consular processing. Somebody that has for example, L1. So somebody's on L1, they're working for a company, so their employment is going to continue, and they cannot really start employment right away. So maybe for them, counselor might be an option. Somebody who's on OPT who wants to get the flexibility of OPT, for them, counselor might be an option. But for people who don't really have work authorization and need work authorization, probably change of status is probably the only option. So every case is different. But again, for some people, counselor processing could be attractive.
Cool. Thank you so much. And Basma, thank you so much for your question as well. I hope you got your answer. Let's move on to Ria's question. She has two questions, follow-ups. My H1B got selected in lottery from India in 2022-23 and received approval in February 23. I didn't appear for interview due to market conditions, and in January 2024, I again received RFE, and my employer responded to it in March, and I received denial in April. I am waiting for the notice. What are my options now?
So from what I hear, the case got approved initially, and then they had a notice, some notice requesting more evidence after the approval, and then eventually it ended up being denied. And
Denied.
to me, what that means is initially they got an approval, but USCIS, they found something, and they issued a notice of intent to revoke. And after the employer responded, they revoked the previous approval. And the reason for that, more than likely, is we have seen a lot of cases with multiple registration issues. And cases with multiple registration issues initially got approved when USCIS found out that the employer has colluded with somebody for multiple registration.
Okay.
And they got notices. And after that, the cases got denied, revoked. My guess
Okay.
is if something like that happened to your case, you are not cap exempt. You have to go through the lottery once again. And your employer might be the best person to let you know what exactly happened or share the copy of the denial with you. But if USCIS revoked the denial, revoked the approval, what that means is you're not cap exempt. You have to go through the lottery one more time, and only then you can go for stamping and get your H1B visa. So check with the employer. My guess is it's probably multiple registration or something of that sort, which is what
Mhm.
caused USCIS to come back after the approval. So after the approval, if they came back and basically denied this case, I think the employer has done something that caused this issue. But again, from your standpoint, what that means is you cannot use this for transfer. You probably have to go through the lottery one more time, and then get a new approval before you can apply for a visa.
Okay, thank you so much for taking that up for Ria. Thank you, Ria, for your question. Now let's move on to Harsha Jain. I am on H1B visa. I got laid off on 10th March 2024. So technically, my grace period ends on May 10th, and that is in just about 8 days. I got a job offer from a company which filed my H1B petition on April 8th, 2024. Today, I got another job offer from a new company with a better role and salary. They are ready to file H1, but they will be able to do so by 20 May only, beyond my initial grace period. So the question is, so can my new company file me H1 transfer, given that my current transfer is pending and I will be out of status as per initial deadline?
So I think, as you know, you have only 60 days for the grace period. But the good thing is, on April 8th, a company filed for a transfer for you. So within the 60 days, a company has filed a transfer. And what that means is, if you have started working for that company, this new company that filed the transfer on April 8th, then what happens is, since you're working for that company, your 60-day clock has stopped. And when this new company files your H1B, say on May 20th, you can always show your employment with this company that has filed your H1B. And if you're able to prove that you started working for this company, and now by starting to work for that company, your 60-day clock has stopped because you have a petition filed and you started working for that company, then you will not have a problem of 60 days because you do not have a gap of more than 60 days. So the idea is, you don't exceed 60 days of unemployment. So since you did not have 60 days of unemployment, assuming you started working for this new company that filed on April 8th, you should be okay. This new company's H1B should be okay. My suggestion is probably better to ask them to do it in premium, because worst case, if they say you're out of status, they will still approve your case. You can still get this approval, go out of the country and get a visa and come back. So if you fail to maintain status, you can still get an approval and get a visa and come back. So talk to your new company about this. But my guess is, assuming you started working for this other company, you more than likely will not have any issue at all.
Okay. Thank you for taking that up for Harsha. Harsha, I hope you got your answer, and I hope it's much clearer now. So if you have any more further questions, you can keep dropping them. And we'll move on to Ram's question, which is already on the screen. He's on YouTube asking, what are the benefits or risks of H1B consular processing versus change of status? Very much to the topic. And how do H1B RFE trends impact consular processing versus change of status?
Sure.
Thing.
So the biggest benefit of consular processing is you get an H1B approval, but you're allowed to continue to maintain the existing status. So, for example, if you are on F1 OPT, maybe the initial year of OPT, you have 2 more years of OPT. The advantage is even though your H1B gets approved, you can maintain F1 status. Why do you want to maintain F1 status? There are some reasons. With F1 status, you have a lot of flexibility. Say if your company changes your assignment from one location to another location for whatever reason. With H1B, they're supposed to do an amendment. They're supposed to file an LCA right away. They're supposed to do an amendment right away. So H1B is very restrictive. With OPT, you get some flexibility. So you don't have to do an amendment right away. You simply just notify your DSO. So there are a little bit advantages of somebody being on OPT. So if you want to maintain your OPT because you have OPT for a long time, that's a big advantage if you want to do it in consular processing. If you do it as change of status, what happens is the day your case gets approved, October 1st, your service will get terminated. Your OPT card is not valid anymore. And what that means is you will be an employee of that company. And tomorrow, if you're laid off, you have 60 days of unemployment, and otherwise you're out of status. So there are other issues. So change of status means your F1 gets terminated. You are on H1. And H1 is a very, very restrictive visa in terms of the regulations. You have to be worried about your amendments. Anytime there is a change in your project assignment, material change, amendment needs to get filed. And you travel out of the country, you have to get stamping. So these things are there. With consular processing, say you have OPT for 2 more years. You already have an F1 visa. You have to travel, come back on the same visa. So that's why everybody's case is different. For somebody, change of status might be beneficial. For somebody, consular might be beneficial. Why is change of status beneficial? Because you don't have to leave the country. So you get change of status, you can convert to H1, you can start working for the new company without leaving United States, without getting a visa. With consular processing, you at some point of time, you have to go out of the country, get a visa and come back. The day you get a visa and come back is the day you actually start your H1B program. So that's another thing with consular processing. And again, another advantage, disadvantage. You can only work for 6 years on H1. So you cannot cross 6 years. So what some people try to do is they try to utilize their entire OPT or STEM OPT. So 1 year or 2 years, if they have additional OPT or STEM OPT, they can use it. And then they get their 6 years of H1. Because if you start off with change of status, you convert to H1B on October 1st. So your H1B 6 years clock starts right away. So you might not be able to extend it. Okay, so that's another difference between consular versus change of status. In terms of the RFE trends, with consular processing, we don't get RFEs related to maintenance of status. With change of status, we typically can get RFEs regarding the validity of your current status. So if you're somebody on F1 visa, USCIS could raise issues about your F1 visa. They can say, hey, when you're on CPT, give us documents about your CPT, give us documents about your OPT employment, and so on. With consular processing, typically there are no such kind of RFEs. So those RFEs are minimized with consular processing. But the actual H1B petition as a whole, the burden of proof is exactly the same for both counselor and change of status. So if you're talking about the salary requirement, the position, the actual approval of the petition itself, both are exactly the same. There is no difference between, I mean, it's not easy because it is counselor or change of status. So only the maintenance of status part is what becomes easier with counselor processing.
Thank you so much, Chan, for clearing that out for us. And definitely, friends, we will take up all of your questions. So let's go to Minu's question. And that is, what are the implications of a denied H1B visa application for consular processing versus change of status?
So if the entire H1B is denied, basically you cannot use it for transfer. So, but again, what happens in many cases is the H1B gets approved and the change of status part gets denied for many people. And I think this question is probably for those kind of scenarios. So if your H1B gets approved, but your change of status gets denied, you're still good. If your change of status gets denied, you can still use that H1B approval, go out of the country, get stamping, and then come back. So some people, what they do is they go ahead and ask for a change of status. For some reason, if USCIS says, no, we cannot approve your change of status, we will deny your change of status, but we will approve your H1. That is a possibility. That could happen. And if that happens, what will happen is USCIS will give a approval which says change of status denied, but H1B approved. You can take that copy, go for stamping, and come back. So that also happens quite some time for a few folks. And if that happens, even if your change of status is denied, what that means is you are still able to get consular processing because your underlying H1B got approved.
Okay. Okay, that's very interesting. Thank you. Thank you so much for taking that up for Minu. Now let's take, I think, this last question for the day from the viewers out there. This is from Roop. Roop is asking, I applied for STEM OPT and I got RFE, and I'm applying through attorney. Feels like 50-50 chances upon my approval. Can you suggest how to handle this situation? What is the best university which is for day one CPT? I am currently working.
Sure. I think again the STEM OPT RF is kind of a recent trend, and I'm surprised that I've seen so many RFEs this year, because normally 765s, these are applications that the applicants file themselves. A lot of times the school DSO or the school office, they typically provide help to apply for the 765s, and normally it is very straightforward. All you do is you show your I-20 and you show your employment offer. Typically, if it is a STEM OPT extension, you show your 983, and cases very easily get approved. However, this year what we are seeing is we are seeing weird RFEs which are probably scaring people, because they talk about things like show me your, for example, your tuition receipts. Not only that, show me how you got all the funds to pay your tuition. Show me all your bank statements. Show me all the transactions in your bank statement. And what happens is sometimes it kind of scares people. The reason is, I had one person, and this person apparently he lives with roommates, and because they're sharing expenses every month, he has some Zelle transactions to his roommates for rent, for food, and other expenses. And the thing is, there are so many of these transactions. I mean, when I say so many, like 3 or 4 probably, not many, but recurring transactions. And now this guy is worried. Hey, I have this like Zelle transactions. Should I be worried? Because the RFE is saying provide all these bank statements. So I think when you say I have 50-50 chances, feels like 50-50 chances. I see your concern. The reason is USCIS is issuing all these RFEs. That being said, I think even if you don't provide all the documents, as long as you can provide your company, your STEM OPT 983 is a legitimate offer, your tuition has been paid, you graduated, at least the basic things. In general, we are seeing approval. So even if you don't provide each and every document that USCIS is asking, on a whole, if you can show that you are maintaining valid status, you have not done anything against the law, we are seeing cases getting approved. So I think your case can get approved. That being said, I see your concern. Your concern is, what if it gets denied? I need to have a backup option, which in your case, you're mentioning the CPT. And again, you have to be cautious about CPT. CPT is legitimate only if certain conditions are followed. And those are, the university should be a legitimate university. The university should have a CPT program, and they should require immediate CPT participation, because if you join a university and the university does require CPT in the very first semester, USCI sometimes comes back and asks for evidence of that when you file for your H1B. So anytime you take your day one CPT, research your school. And I cannot really say which school is the best, because I do see a lot of people, a wide variety of universities offering CPT program. You might have to do some research. You might have to talk to your other friends and colleagues and see what kind of universities they have applied. But what I suggest is make sure you get a good referral. Make sure you talk to somebody and knows that it is a legitimate school that offers legitimate program, and you intend to actually attend those classes. Because if you're taking CPT and not really attending classes, you are trying to kind of circumvent the rules. Day one CPT could cause you an issue. So do your research. Make sure the school is legitimate. Make sure your friends who have attended school. Make sure you're in your case also you have plans to attend school in person. There are very strict rules. But again, there are a lot of good schools who have CPT programs. So do your research. And in your case, if you feel that your STEM OPT is a 50-50, I think trying to apply to another school is probably not a bad option. And also know this thing. When you're on F1 program, you have grace period. So tomorrow, if your case gets denied, you have 60 days of grace period. So within the 60 days, you will be able to transfer. So talk to your attorney about the grace period, because even if your case gets denied, if you're able to do certain things within your grace period, you might be able to change even at that point of time. So what I would do is there is nothing to rush. Get your RFE answered. If something bad were to happen, you will still have grace period, the F1 60-day grace period. And during the grace period, make sure you talk to your school DSO and get things done. But before that happens, I think maybe this week, talk to your attorney who's handling your STEM OPT RFE. Talk to him about your grace period, and also take their suggestion.
Thank you so much, Chand, for your advice. And absolutely, Roop, I hope that was very helpful. I'm sure it must be looking pretty enlightening. This whole session we had today was very insightful. Thank you so much, Chand, for doing this. And this is the second episode on this topic. So hopefully, pretty much we've covered a lot of it. And folks out there, if you have more questions, I would just suggest you could also check out our previous episode. We also covered a lot of questions from viewers out there. Maybe you have something which could be insightful to you. So don't forget to check us out, and also subscribe to our channel, Immigration and Jobs Talk Show. That is our handle. Subscribe to us so that you can always indulge in these very insightful discussions we have each time with these attorneys. And Chand, today, thank you so much for doing this. It was a very awesome time, chatting with you, and also getting to learn so much about this topic today, H1B RFE trends, and then, of course, consular processing and change of status. So thank you.
Thank you, Nipasa, and thank you, everybody.
Thank you so much, Chand. I hope to see you again very soon, hopefully next week. But I know you're very busy, so all the best. Have a great rest of the week, I would say.
Yeah, thank you, Nipasa.
All right, bye-bye. Have a good day ahead. And folks out there, thank you for joining in. This is Immigration and Jobs Talk Show. Once again, I would tell you, don't forget to subscribe, hit the like button also, and share, because these are very insightful discussions, and I'm sure people can benefit. So if you have friends or folks who are, who would be benefited from these topics, share these links. Thank you so much for joining in. And of course, stay with us. This is Immigration and Jobs Talk Show, and have a great Thursday ahead so far. Okay. Nipasa Pradhan now signing off from Immigration and Jobs Talk Show. Bye-bye.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com.